I'm at 447.
Thank you. At paragraph 3.3.4, this is now the internal auditors. They say that they have observed the following red flags and or evidence of fronting in the bid of Medicare 24 Tshwane district. And they begin to detail in the paragraphs below why they have indicated that there was fronting in the bid. Can you just begin to read out what is indicated, maybe starting from paragraph 3.3.4.3?
Thank you very much, Honorable Chair. I will read 3.3.4.1, and it says the bidder is a registered company with company registration number. The company was established in 2019. A company was registered and is registered on CSD and was vetted by the National Treasury. I do not have enough information to substantiate why that was an anomaly.
Okay. But, and then now at 3.3.4.3, can you indicate what the internal auditors have indicated about their finding that there was fronting? Their
report says there is only one director of the company who is an African male. The address of the registered office is 103 North Rand Road, Baden-Boksbeek. I don't know how that constitutes fronting.
Yes, I was asking if you could read 3.3.4.3.
Oh, 3.3.4.3.
Yes.
Thank you, Honorable Chair. The bidder is operating under franchise agreement with the franchisor with its own company registration number. The bidder and the franchisor share the same business address. The bidder did not indicate in the bidding document the third-party supplier arrangement.
What do you understand that to mean?
What I understand this to mean is that in the tendered returnables, there is no evidence that was found by the auditors with regards to an agreement between the two parties.
Yes, but as I read 3.3.4.3, sorry, it's difficult, it's just, they say that when you look at the entity, it is operating under a franchise agreement or tries or purports to operate under a franchise agreement, but that was not indicated in the bidding documents that there would be a third-party supplier. Now, would that be the kind of requirement that would have caused the bidder to be excluded?
We have stipulated in our tender documents that if you are not operating at your premises, you must provide us with the water and lights account, or you must give us an agreement where you have with the person that owns the building. In this instance, it's not just about rental, it is about operating and utilization of facilities in that space. It appears that the bidder did not own the facilities, but has a franchise agreement that was picked up by the auditors.
Yes, but what the auditors indicated 3.3.4.4 is that that franchise agreement was not signed by the franchisee and so could not be relied upon at the time of bidding. So going back to my earlier question, wouldn't that have been a mandatory requirement that had to be complied with in order for this bidder to have progressed?
Right. Let's one, the franchisor signed, the franchisee did not sign, and the document was available. The question that we can then ask is that is 3.3.4.3 being nullified by 3.3.4.4 because 3.3.4.4 says an agreement was there but not signed, and 3.3.3.43 says there was none. So internal audit may have to answer that one. I am not, I cannot vouch for any of the statements.
So, but whether there was none or it was not signed, wouldn't in both circumstances it mean that the mandatory requirement was not complied with? Either there was no supplier agreement or there was a supplier agreement that was not signed. But under both circumstances, what I'm asking, doesn't that mean that there was that particular mandatory requirement to show a third-party supplier was not complied with?
The requirement is that there should be one if the bidder is not the owner of the facility. What this 3.3.4.4 seems to suggest is that the franchisee did not sign. What it is not saying is that the franchisor signed and what the nature of the relationship would have been. I would presume that in the clarification, when legal was writing to the bidder, clarifying issues before disqualification, they would have clarified this. I'm not privy to that. But the document must be complete. That's what I'm saying.
Yes.
Yeah.
But what I'm asking you, and maybe I'll ask, what it clearly indicates was that the document wasn't complete.
What it indicates is that the franchisee did not sign, which makes the document not to be complete.
So doesn't that mean that a mandatory requirement wasn't complied with?
It would appear, well, it is not being complied to if the signatures are not complete.
Just to clarify, is that a yes?
It's a yes.
What was the role in the franchisor and the franchisee? What was their role in the bid? He seems to suggest that maybe because the owner of the franchisor didn't matter.
Chair, if I may also indicate is that the internal audit had qualified that, if I may read it, the franchise agreement is not signed by the franchisee and cannot be relied upon and was not a requirement at the time of the bidding. That's what the statement is saying. I do not have the document to verify which was the requirement. So it gives two contradictory statements, that sentence that is written there. Maybe they wanted to say and was a requirement, yes. But what is written here says and was not a requirement.
Yes. Can you go to 3.3.4.8?
The bidder submitted a company profile of Medicare 24 holding and not the third-party supplier's declaration as required by the special conditions of the bid. It should note that Medicare 24 holding did not bid and therefore their company profile is irrelevant for this bid. By submitting the company profile of the Medicare 24 holdings together with the bidding documents, the bidder assert that the bid will be executed by Medicare 24 without making third parties declaration. The finding is correct.
That finding is correct.
Correct.
In so doing, would that have been a mandatory requirement that was not complied with?
Not mandatory. It was part of the criteria for evaluation.
Can you go to 3.3.4.10?
3.3.4.10, the pricing schedule submitted by the bidder was different from the pricing schedule issued with the original bid documents in that the control numbers on the top of I would assume that it says on top of each page were changed. the SBD 7.2 bid cover page and pricing schedule were submitted for forensic analysis to establish whether they were signed by the same person. The forensic analyst established that the signature of the bidder on SBD 7.2 did not correspond with the signature of the bidder on the submitted pricing schedule. Therefore, the pricing schedule submitted by the bidder could not be relied upon as it lacked integrity.
What does that mean?
The specialists had a look at the signature that was attached to the document. They are specialized. They are specializing in that form. The question that could be asked is, would any reasonable man could have seen that the signatures were not the same? The answer is no.
As I read 3.3.4.10, they say more than just the signatures. They say essentially that the pricing schedule had been tampered with, and that it was not the original bid document, I'm reading from the second line, that had the control numbers that were submitted. So, and you can clarify or with me if I'm incorrect, but as I understand it, there are certain forms that have particular control numbers that must be submitted with those original numbers and so on, and the pricing schedule is one such document.
Correct.
And that in this case, that pricing schedule had been tampered with. And so it was not the original numbers or control numbers of those documents that had been used.
It's an audit finding. The BEC should have picked up the format of the document, and indeed, if internal audit picked it up, and it is warranted. One of the tender requirements that we have is that the submitted schedules should not be changed or altered in any form. If they have been altered, this should have been a disqualification.
So this requirement that the pricing schedules that were submitted had been tampered with, this should have resulted in a disqualification.
Correct.
Can you turn to page 450? This is paragraph 3.3.8 of the audit report. Can you read, because it's a long paragraph, can you read the finding just before where they discuss the Treasury regulation?
Right. It is alleged that the bidder committed an unethical conduct in respect of the procurement process in another organs of states, that is Gauteng Provincial Government at Tembisa Hospital. There were allegations of alleged procurement irregularities committed by the Director of Medicare 24 Tshwane District prior the evaluation of the bid. The bid should have taken into the BEC should have taken into consideration the allegations raised on the media about the director to inform their due diligence methodology. The due diligence did not ascertain all facts concerning the bidder, resulting in a material control weakness.
What do you understand the internal auditors to have been flagging there?
All that internal audit is saying is that with the media statements that were made concerning the director of this company, the bid
and this is Mr. Matlala?
That is Mr. Matlala. The bid evaluation committee should have disqualified the company. Let me just clarify what is the correct process. The correct process is that when you evaluate the tenders, you evaluate the tenders as received. In your report, you then highlight the issues that should be considered by the bid adjudication committee. If those concerns that were highlighted by the bid adjudication committee are outside the tender process. The bid adjudication committee will adjudicate the tender. If this supplier becomes the winning bid, the bid adjudication committee will not award that tender. They would have to refer that matter to legal services, so that legal services can give direction with regards to what needs to happen with regards to that bid. You do not disqualify any person on other matters that are unrelated to the tender when you do evaluation and when we do adjudication. You highlight those in the report, and you make sure that legal services assist you with crafting a report for disqualification of that supplier. Treasury regulations indicate that if for any reason the bidder who has received the highest point, they are not saying disqualified for other reasons, that has received the highest point cannot be appointed. Such a bidder, such reasons must be given, and such bidder should not be appointed or be awarded a tender. Had we known as bid adjudication committee, I'm not sure to what extent the bid evaluation committee knew about the issue of Mr. Matlala. We would have, as I've indicated in my affidavit, we would have flagged this with legal services, and legal services would have crafted us a reason which justifies why the supplier should not be appointed.
Thank you. General Fani, as I read this paragraph, it's maybe making 2 points and to discuss with you. The first point that it makes is that there should have been a due diligence process that picked up the fact that Mr. Matlala was a person who was in the media reported to have been involved with Tembisa Hospital. And that there was a failure in the due diligence process regarding that. What I understand you to be saying is that had you known, you would have gotten a legal report or so on. But can you answer the first question, which is whether there was a failure with the due diligence process, that it should have picked up that this was a bidder who was alleged to have been involved in procurement irregularities in relation to Tembisa Hospital? Right.
Honorable Chair, I wouldn't say there was lack of due diligence done. We rely heavily on information that is recorded for us. In the CSD report, I would refer to page 453. In the CSD report, the CSD report indicates.
Can I indicate that the CSD report is at page 457 of the annexures?
I've got it as 454.
Yeah. Let me just check.
In the CSD report, this does not talk about Ket Matlala. I'm looking for his name. It talks about Vusimuzi Matlala, but that's immaterial.
That is, as I understand it, the name Kat is a nickname.
Yeah.
So I think it is Mr. Matlala.
As I've indicated earlier, I had no knowledge of Vusimuzi Matlala. I may have heard in the news that there's issues at Tembisa, but it for me personally, and probably for other members of the committee, that for us to link him at that time to Tembisa did not happen, and for a reason that it did not appear to us at that time that this person is the person that is being wanted. But importantly to note is that we rely on information we get from CST. The framework that governs restriction of suppliers in government clearly indicates that a department or entity that has experienced any anomaly with regards to the supplier, either in terms of crime committed or in terms of performance of the supplier, initiate the process for restriction. It would appear that, based on the CSD report, that such a process was never embarked upon by any department, resulting in this individual or this company being cleared on CSD not to have been restricted. We have also gone to the register of restricted suppliers that National Treasury publish. We have looked for both the directors of the company, and we have looked at the company itself. There is no such a restriction. But I'm just saying, from a procurement process perspective, we have clarified that had we known that this person, Vusimuzi Matlala, or the company that he operates under is suspicious, as I've indicated, we would have flagged it with legal, and legal would have provided us with direction that this is indeed a suspicious transaction that SAPS is about to conclude.
So, and I understand what you're saying. You're saying within the formal government structures, there was no restriction on the company or the person, such that it was not indicated that this was a blacklisted entity,
Yes.
or a restricted entity. Am I correct in that understanding?
You're correct. From both CSD perspective as well as the registers that National Treasury keep, that we look at before we conclude on any tender process.
I guess the question, and as I understand the issue that's being raised by internal audit, is this, though, in the public, was an entity or a person that was flagged as having been involved in significant public procurement irregularities at Tembisa Hospital. This was and they have held the view that at least that should have been flagged by the bid evaluation committee. So I'm separating two. The one is the formal registrations that exist on the CSD, but whether, as they indicate here, that considering the extent of the allegations that were in the media, were those allegations completely irrelevant to the tender that was being adjudicated by the SAPS?
I'm unable to answer on behalf of BAC. Certainly on my behalf, I did not find a link, and I'm sure the members of the BAC at the time, otherwise they would have flagged it in the deliberations. At the time of the adjudication, I did not even try to establish the link, because it did not appear in my head that there is a link between this Matlala and the Matlala that is, or any other Matlala for that matter. The assumption that is made is that the bid evaluation committee and the bid adjudication committee ought to have known, and I dispute that.
And maybe just the one last point before I move off this. I think as I read 3.3.8, the comment that is being made by internal audit is not that you ought to have known, but that a proper due diligence ought to have taken place that would have picked up this widely known information. But
the procurement due diligence was done. The procurement process cleared the supplier and the director based on the treasury regulations that we need to comply to. Any other form of due diligence that ought to have been done is not part of our process, and I would not speak to it. It is unknown to me.
okay. So if you turn to page 4.5.1,
is it 5?
451.
Page 451. I'm there.
added
I'm
a
there,
lot of-
Chair.
Okay. The general findings by the internal audit is at 3.4.1.1 that the evaluation process in use is extensively dependent on the use of manual documents, therefore is open to abuse and manipulation. What is your comment on that?
Correct. Correct. I have flagged our technology management services for a procurement of technology in order for us to utilize technology. I have indicated in my affidavit that the integrated finance management system that National Treasury is working on for years now should have assisted government in making sure that the manual submission of tenders are eliminated. We are stuck with manual elimination at the moment because IFMS has not been implemented. I have asked technology management services to ask for an exemption at National Treasury so that we can procure a system in order for us to alleviate some of these issues. We have been using another system in our quotation process called Intender. That system has fallen off because of the disputes between SITA and the service provider. So we are back to manual system with regards to that. We are testing on the quotation side a new process on CSD. We will implement it shortly. It's one of the developments that we are doing, but it only deals with the quotation process. The tender process is still manual. For whatever reason, IFMS has not been implemented, and it is impacting on us and how we can fully have an automated process for us to eliminate some of the challenges that we are experiencing at the moment. Until then, we are stuck with the manual process.
At paragraph 3.5.1, the internal auditors say that raise the issue with somebody or a position called a facilitator in the evaluation process. And they say that the role of the facilitator in the bid evaluation committee previously exposed and is continuously exposing SAPS bidding process into corruption risks. And then at 3.5.2, they give two examples of cases where the person or the people who occupied the role of the facilitator was then subsequently being charged with procurement fraud. Can you see that?
I can see 3.5.1.1, 3.5.1.2.
Yes. And those are, as I understand it, examples of previous cases where the person who occupied the position of the facilitator was then subsequently charged with procurement fraud. What is your comment about this finding that the use of the facilitator causes corruption risks in the bidding process?
I'm not sure how internal audit qualified that. The role of a facilitator is not above the role of the chairperson of the bid evaluation committee. The facilitator's responsibility is mainly to be in the position to submit the documents to the members for perusal and to keep the record of the discussions. The role of the chairperson is to ensure that the information, in fact, the role of the chairperson and the role of the members of the BEC is to ensure that the information that is captured on the sheets before they sign, these sheets were signed by members of the BEC indicating the correctness of the information that is submitted. So their role is to ensure that they double check and make sure that the correctness of information that it was at their disposal is indeed captured on the sheets and is indeed captured on the report which they have signed. How the role of a facilitator has rendered the process into corruption, we will look into that. I'm not going to dismiss it. I would just want the internal audit to advise me proper so that we can write it off in the processes. However, there needs to be somebody in the process who dishes out the documents, and who makes sure that there is record keeping. And that role is done by a facilitator. I'm not sure what we will call that, maybe a typist or a data capturer, but he will still be fulfilling exactly the same functions. What is of concern here is that the role of the chairperson of the bid evaluation committee seems not to have been adequate if you look at the things that happened in the bid evaluation committee. And we need to strengthen that role and make sure that the chairpersons of the bid evaluation committee play the role that they ought to play in making sure that the deliberations of the bid evaluation committee are done in such a nature that there are no audit findings.
Who was the facilitator for this particular bid? I see the list of people. You can find it at 369.
I don't have 269.
369, page 369
369, oh, okay.
of the Annexure bundle. Who were the facilitators in this evaluation process?
I don't want to say the wrong name. It was Captain Cartwright.
It was Captain Cartwright.
That's right.
Okay. Can you go to the exhibit bundle? It's the small bundle. Let me just find the exact page. Just apologies, I can't seem to find the exact page I'm looking for. Not here. What page is it on? Page 18. Okay. It's titled Tender Profit Cat Matlala rented SAPS medical clinic 6 months before the award. Okay.
Okay.
Can you see that?
Yes, I can see that. Thank you.
Can you see that? If you go then to page 17,
Got it?
and there's a heading that says backhand cash. Can you see that?
I've got that.
And then there's a section that has a red line.
Got that?
There's paragraph 1, paragraph 2, paragraph 3. On the 4th paragraph, can you see that?
I see that.
It says that Matlala channeled cash to Captain Brian Cartwright through a proxy company. Cartwright was the facilitator of the tender for the SAPS supply chain management. So, can I get your comment on that?
This is a media statement, and as far as I'm concerned, there's a forensic investigation that is done. Some of these things will be clarified by that forensic investigation. I note the statement, but that's as far as I can say.
So, and I understand you saying that this is an allegation that arises from the media statement, but in the internal audit report that had been furnished first in January and then in April, they particularly identified the person who sits as the facilitator as being the corruption risk. Is that correct?
Yes, they have flagged that the person is a corruption risk. And they have also indicated here in the media report that he got the money. If this is proven to be correct, then disciplinary processes must be initiated against this individual. In fact, even criminal charges must be laid against him.
Since the audit report was first, the preliminary one was furnished in January and then the final one in April, what steps has been taken to investigate the allegation that this person who played the role of the facilitator was the corruption risk or was one of the corruption risks?
That role was given to internal audit to do, and the internal audit subsequently did the audit, and the forensic audit is underway. What I have done on my side is to make sure that this individual does not get appointed in any committee to play this role until such time that his role in this matter has been clarified.
So he remains within the procurement department?
He is within the procurement environment doing administrative duties and all other matters, but not in the tender process.
And then I just want to go back to the audit report. That is correct. The internal audit report said that there is a particular role called the facilitator who has in previous cases already been shown to be a corruption risk, and they flagged that as a corruption risk. Subsequently, media reports indicate that the person who may have played the role of the facilitator in this tender received money from Mr. Matlala. So yes, that is a deduction, but what I'm asking you and for your comment really is that as early as January and finally in April, this particular role that is played within the procurement environment of SAPS is being flagged as being a massive vulnerability and what gets targeted for corruption. Your comment?
I would, as I've indicated, the role of a facilitator ought to be that of making sure that the documents are provided to the members and making sure that the scoring and documentation of such discussions is updated and is accurately captured. That does not supersede the role of a chairperson who has an overall accountability. And that does not supersede the role of the members of the bid evaluation committee, who must make sure that what they are signing for is indeed what is correct. If for whatever reason that person is dominant in the discussion and in the processes, which it shouldn't be, then we have a challenge with regards to the whole makeup of the bid evaluation committee and the strength and the power that should be exercised by the chairperson of the bid evaluation committee. And I have serious concerns if that's the case. It has been flagged in the report, and we have looked at it in our discussion in August when we had a three-day session with my team to make sure that each committee and how it functions needs to be strengthened so that we do not have repeat audit findings of this nature.
General Fani, at the paragraph